Welcome to Rapid Fire Wednesday, Q&A for immigration professionals. I'm Kimberley Robidoux at WR Immigration's office in San Diego, and I'm joined with co-managing partner of our Boston office, Miki Matrician. Hey to you, Miki. How's everything going today?
Good. Hi, Kimberly. So for today's installment of our three-part series on PERM, we wanted to talk about PERM recruitment, given some big cases involving PERM practices at a couple of multinational companies. It's been a little while since these decisions came out, but we thought that we would walk through some of these issues because it does involve penalties for these companies. So just the background is that in October 2021, a settlement was reached between Facebook and the U.S. Department of Justice's Immigrant and Employee Rights Section, also known as IER. And following their investigation of Facebook with regard to the PERM recruitment practices, and then in November of 2023, the Justice Department reached a settlement agreement with Apple following that investigation and scrutiny of Apple's PERM practices as well. And so there were, as I said, huge penalties. And it's still, even though it's been a little while, it still creates a lot of confusion, not just for HR and global mobility departments, but also for immigration counsel. So, we got some questions from our clients on how best to avoid these outcomes. So we thought it would be a great topic to address here. So before we get into the Apple and Facebook cases, let's kind of set the stage a little bit. Kimberly, can you explain what we mean when we talk about PERM recruitment? What is that exactly, and why should HR and global mobility professionals care?
Absolutely, Miki. So the PERM labor certification process is for organizations to do what we consider testing the labor market to determine if there are any able, willing, available, and qualified U.S. workers for the position for which HR and the company are working really hard to sponsor an individual foreign national for permanent resident status. So a part of this process is the requirement by the Department of Labor to, in essence, recruit, which means to post specific ads, to conduct that recruitment, to determine, again, if there are any able, willing, available, and qualified U.S. workers, and in doing so with good faith. So it's really important that employers conduct these recruitment postings in good faith. Part of the process, right, is that the company for professional workers is required to post mandatorily in 3 different types of formats. One is 2 Sunday editions of the print newspaper of general circulation. Super old school, but Department of Labor has not changed that. I mean, that goes back to the 90s from when I was initially doing this, so a really long time. The other or second way that employers are required to recruit is to post a notice on the State Workforce Agency's job board or job order for a period of 30 days, plus any veterans period of hold that is required by that particular state. And then the third one is by posting, again, physical hard copy posting at the work site where it's intended for the individual to work. And this needs to be posted for 10 business days. If a company has an intranet, they need to post on the intranet as well for 10 business days. For professional positions, which is what mostly you and I work on, Miki, an employer has to do 3 additional forms of recruitment. So those other forms of recruitment can take the forms of posting on the company's website, posting on a commercial website, doing a radio ad or TV ad. If an employer has an employee referral program with financial incentive, they can utilize that. They can also post in an ethnic or local newspaper. There's on-campus posting, and the headhunter, it can be utilized as well, which is not typically seen, at least with what I do on a day-to-day basis. So this is all in order to protect the U.S. workers. And in a company, if they want to sponsor a foreign national, must go through this big exercise of testing the labor market.
Right. So we do, training calls with hiring managers and technical recruiters that help HR with technical screenings of the candidates that respond to these ads. And, we do that so that they know what their role is and what to expect. And if they're new to PERM, they would ask us, why would we want to recruit? Like, we have the person we need for the job. They're great for this job. She's on an H-1B. That's why we hired her in the first place. So we want you to get her green card so she can work with us in the long term. So can you explain that to everybody, Kimberly, the purpose of these recruitment campaigns?
Yeah, absolutely. And, Mickey, it reminds me back when I first started learning about PERM, my former mentor said to me, think of this as a game. It's run by the Department of Labor. You need to understand or just play by the rules of the game. And if you don't play by the rules of the game, which are the DOL's regulations, then you're not going to win. So if you want to win, you have to play by the rules. That made me understand it a little bit better. And then further, what helped me understand it and what we use to explain to managers as well as some HR professionals is that H-1B worker or another non-immigrant, worker who is filling that job right now. They're there, they're performing the job, they're sitting in the chair, but they're only temporarily sitting in the chair because they are not a U.S. worker, which is a U.S. citizen, a U.S. permanent resident, asylee, or a refugee. That temporary non-immigrant worker is just there temporarily. They're just sitting in the seat. They're holding it until there's a qualified U.S. worker who comes along, or hopefully, if there is not a qualified U.S. worker that comes along, the individual will be able to sit in that seat permanently.
Gotcha. So what if, though, the employer finds a minimally qualified U.S. worker that comes along in response to these ads? I mean, we get this question a lot from sponsored employees who are really anxious about a U.S. worker pushing them out of their role. How do you explain that?
And that's a really valid question. And it also, it's a stressful process to go through the labor certification process and to also be fearful of potentially losing your job if the company finds a qualified U.S. worker can be really difficult. So the way that we explain it is that because this is something that the Department of Labor requires, and that is, recruiting and testing the labor market, an employer is never, ever forced to hire a U.S. worker or anybody for the role. So if there is an able, willing, available, and qualified U.S. worker who applies for the position, the company has a choice. If there are multiple positions open, they could potentially offer the job to that U.S. worker. If there's multiple positions, that U.S. worker could fill one of the positions and the company could potentially continue to move forward with the permanent resident process for the foreign national. Or if that isn't the case, and we know a lot of situations that doesn't happen, the company can stop the labor certification process, wait several months, and then potentially start again. So those are, some things that the company might need to consider, especially if somebody is getting towards the end of their maximum non-immigrant status. As we mentioned last time, the sooner a company starts the permanent resident process, the better it might be. And this is one of those little, I guess you could call them glitches or issues that could come up that could prevent an individual from being able to remain in the U.S. throughout the whole process.
Totally agree. So, what if an employer asks you, so we really want to try to avoid finding a U.S. worker. Can you post all the ads in a place where it's least likely to yield a U.S. worker that's qualified? How do you respond to that?
That's a good one. We usually say, hey, employer, that is not recruiting in good faith. So you want to make sure that you're recruiting in good faith. And I know it's tempting to say, hey, look, this is the game. This is Department of the Labor's game. So we're just going to play the game and we're going to post specifically in places that aren't going to attract a lot of candidates. However, that is not the intention of this process. And in order to proceed in good faith, an employer has to look at where they're recruiting, how they're recruiting, and make sure that they're doing so in a manner that is not only compliant with DOL's rules, but also shows that they're not trying to, I guess, beat the system.
Yeah, totally. So that's a good segue to the Facebook and Apple cases, right? Because the Justice Department's investigation was a result of the government finding that these companies really didn't engage in good faith recruitment and that the way the perm practice was run was discriminatory to U.S. workers. And that was sort of the crux of the settlement agreements. And so Apple was ordered to pay a fine of $25 million, train employees that are involved in the perm process on anti-discrimination requirements of the Immigration and Nationality Act. And the trainings was to get these companies to conduct more expansive recruitment for perm so that, in essence, there's a wider net that's being cast, right, to get more applicants to apply and avoid a chilling effect. So this included, things like posting on external and internal company websites, which these companies were not doing. So it goes to your point, Kimberly, about you can't just try to avoid recruitment methods that would yield the most applicants. This is what was the trouble with the recruitment practices of Facebook and Apple. And then the other thing was that the recruitment ads were requiring applicants to send in their hard copy resumes instead of letting them apply electronically. So, normally at Facebook and Apple, they were in their normal recruitment, non-PERM recruitment, they were allowing applicants to file their applications, upload their resumes electronically. But for PERM, they weren't doing that. And so that was the other main part of the Justice Department's issue with these PERM practices. And so basically that by requiring applicants in these tech jobs to print out their resumes and stick the resumes in an envelope, put a stamp on it and walk it to the postal office, that really added some challenges and burdens to these applicants that really, in a way, ended up being discriminatory, right? So Facebook, similar thing, made $4.75 million a civil penalty as well. So Kimberly, can you explain a little bit more about this for our HR and global mobility partners? Go into it a little bit deeper.
Yeah, absolutely. So one thing that, our HR partners need to understand is that, I guess in a way, what was considered good faith in the past, right? Where you're following DOL's rules and regulations, you're looking at the policies. As counsel, we're guiding companies through, the appeals decisions and saying, yes, this was found to be appropriate. Now with DOJ's IER section coming in, they in essence said, no, what you were doing before is not going to be considered good faith because it could be discriminatory to U.S. workers. So where we have a situation that in the DOL's regulations, an employer could ask a potential candidate to send their resume in via mail, as you mentioned, IER has said that's not appropriate if you don't have every candidate send their resume in via mail, because now you're breaking it in half. You're saying, okay, if this is for a quote unquote real position, you can upload your resume online, but if it's for this PERM position, you need to mail it. And, one of the things that was really hard for, I guess, for HR professionals as well as for immigration counsel to understand is kind of how those two things mesh, right? Department of Labor and Department of Justice. And now with what we've seen with these particular settlement agreements, employers can talk with their counsel about what's the best practice for them. But we have definitely seen that, is this normal practice for a company when they're testing the labor market? Well, in real world, when they're conducting recruitment, if they're normally posting on their company website, then they would want to look at posting on the company website for the PERM positions as well. So this really has broken it down into a situation in which IER is saying, if you're not doing essentially the same types of recruitment methods for your open positions that are not your PERM sponsored positions, then you are potentially being discriminatory of those potentially qualified U.S. workers. And as you've seen, Miki, we don't want any employers getting on the bad side of IER and having an investigation opened up against them. So what we're recommending to employers is, what is the normal practice? And let's look at what your normal practice is with respect to recruitment in order to see how to proceed with a PERM position. Now, Facebook and Apple, they settled, so we don't know everything that happened during those negotiations, but this is kind of what we're gleaning from it, as well as from some of the information that IER has provided at different conferences.
Yeah, thanks for all that detail. So, I guess the Justice Department seems to be saying to employers that not only does an employer need to use good faith to test the labor market based on the Department of Labor's regulations, but the employer also has to pay attention to the anti-discrimination provisions of the employment eligibility verification process when it comes to recruitment. Is that how you interpret this too, Kim?
Yeah, absolutely, Miki. And thank you for reminding me of that, because, that's some of the things that we were trying to understand, right? You look at the PERM process, it's the DOL world, but now IER is saying it isn't just DOL's world. It's the non-discriminatory practices And we think of that from the perspective of the I-9 employment eligibility process, but it's more than that. IRs is it's recruiting, it's the hiring process. So this whole testing the labor market for perm falls within that purview. And IRs essentially said, how is it that you're recruiting for these positions and you got 0 applicants when you're recruiting for the perm position, but when you're recruiting for other available positions, you receive thousands of resumes. So that's some of the inconsistencies that IER was looking at from a discriminatory perspective.
Okay. And then can you touch upon a little bit how there could be an intersection between employment law with, immigration law and then the DOL and the DOJ's missions?
Yeah. So one of the things that we're looking at now, and we've done this a little bit in the past, but it's becoming more and more prevalent now, is we know we're not practicing in a silo, right? We're immigration attorneys. We're looking at the immigration process. And we also have to focus on the fact that there might be other considerations from a business operation perspective. And that intersects with employment law, right? So the hiring issues and discriminatory issues kind of intersect with employment law. The other issue that is becoming more and more widespread is with respect to the Pay Transparency Acts. So with the various states now saying to companies, look, you need to be really transparent about what the wages that you're offering for this position. That kind of trickles down now into the ads that are being prepared and posted for the perm positions. So that's another, intersection between the Department of Labor and then employment law issues. And we will address this issue with the Pay Transparency Acts in a future episode.
And I think we're at time. So please join us next week for part 3 on June 5th on the impact of reductions in force and job changes when it comes to the PERM process. If you don't already, please follow us on our LinkedIn page for WR Immigration, as well as for Kimberley and my profiles. And then just as a reminder, we also transcribe this LinkedIn Live and we post it to a weekly newsletter so that you can view it in writing and you can subscribe to it. Thank you so much and have a great day, Kimberley.
Thanks. You too, Miki. Have a good one.